Corpbiz.
The Contract Labour Act 1970, commonly known as the CLRA Act, governs the employment of contract employees and allows for the abolition of contract workers in certain circumstances. Employers regularly express worries about the issue of CLRA. This video will go over CLRA license applicability. Hello everyone, this is Yash Saxena and you are watching Corpbiz. Before diving deep into the topic, let us know about what is CLRA Act. According to the CLRA Act in India, all contract workers are indirect employees of the establishment organization where a contractor has hired them. Any establishment organization that employs contract workers must be registered under this act and require a CLRA license to continue its hiring procedure. Before getting into the procedure, there is another more important thing that employers use, that is applicability. The CLRA Act applies to all establishments where 20 or more than 20 workers are employed as contract workers or were employed any time during the last 12 months. Hence, the CLRA Act would become applicable once 20 or more workers are employed as contract workers on any day in an establishment during the preceding 12 months. The CLRA Act applies to every establishment and labourer if the workers are contracted. Section 2B of this Act provides that the workers shall be deemed to be employed as contract workers when they are hired in or in connection with the work of an establishment by the contractor. Such engagement of the workers may be with or without the knowledge of the principal employer. Whether the worker is employed to do any skilled, unskilled, manual, supervisory, technical or clerical work for hire and reward is immaterial for deciding upon the CLRA license applicability. The Act does not cover establishments where work is only of a sporadic or casual character. Section 1 of this Act further provides that work performance would be deemed irregular in case it was performed less than 120 days in the preceding 12 months or is non-seasonal and performed for less than 60 days in a year. Where the issues arise as to the CLRA license applicability to the contractor, same would depend on the following aspect: whether there exists an open contract between the principal employer and contractor, whether the periodicity and nature of services given by such contractor to the principal employer's establishment are intermittent. At the worker level, the CLRA Act does not apply to the people primarily engaged in any advisory or managerial capacity. In the case decided by the Calcutta High Court, McLeod and Company versus 6th Industrial Tribunal, West Bengal and others, AIR 1958, while interpreting the expression managerial, administrative and supervisory, the Honorable Court noted that the primary work of a person who is essentially engaged in an advisory or organizational capacity would include supervision. But it wouldn't mean that the supervision would be the only function of a manager or an administrator. Therefore, another test which could be considered to determine whether a supervisory work was performed while discharging administrative or managerial position is ascertain if the people were assigned with the duties or responsibilities of distribution of work and power to sanction or refer leave, shift scheduling, increment authority to permit, latecomer, ability to allow a person, leave early, etc. Procedure for applying for the license. The contractors must fill out the application for a license in form number 4. Put a request to the licensing authority along with the application. A security fees need to be submitted at the time of application. The receipt of the payment is paid to send to the licensing officer. Certificate by the principal employer in form 5 stating that he employs the applicant as contractor for his establishment. The licensing officer grants a license in Form 6 after making the necessary checks. You can renew the CLRA license from time to time. But what happens to those who violates these guidelines and rules? A major employer is not entitled to engage a contract worker unless they have secured a CLRA registration from the relevant department according to CLRA Act. The major employer may face up to 3 months in prison. In the event of a breach, he may be punished with a fine of ₹1,000 or both under Section 23 of this Act. So, this was all about the topic. For more information on this topic, you can contact our experts at the given contact numbers. And for more content, please subscribe to our channel Corpbiz.